ever thought that LIEnette's lawyer, Silverscam, would actually be on my side helping me in court as we filed a response to their response to the disqualification of Judge Craig DeThomasis. When I filed for the writ of prohibition, meaning that Judge Craig DeThomasis should be removed from the case in Levy County, Florida, the appellate courts gave LIEnette, not DeThomasis, which is very unnatural, but LIEnette 20 days to respond to why they legally should not remove him. Now, Silverscam on her behalf said a whole bunch of foolish things, such as Jeremy waited all this time, he extended it by 65 days, and here what we have in our response is point number one in our argument. The wrong disqualification motion was even cited by Silverscam. He couldn't even get the information right. And then he talks about preservation. Well, point number two in our argument, preservation applies to disqualification. So we're on page 7 right now, where we talk about this case, Aereo, is supporting of Hale's preservation argument. Now, here's what you have to understand. All the players are the same. It's just a different case. It was Silverscam against Feathers, and DeThomasis was the actual judge. And you're never going to believe it, Feathers actually applies to have Judge DeThomasis removed, writ of prohibition. And the appellate courts say no, Silverscam's on the other side. So what Silverscam does in his response is cites Aereo, which he is now going to eat his words like he never has had before. I gotta say something. I've never had a free lawyer work for me in my life until now. Silverscam. Now, he's charging LIEnette, but in all reality, he's working for me. And here's another thing that we all know already as well. Marli Hughes is now claiming she is no longer part of LIEnette and Crook's legal team. Why? Well, because she now represents
me.
Yep.
She's part of my legal team.
Mm-hmm.
Zero charge. All she has to do is donate her time, and I have to donate my time in return.
Well,
it's win-win.
Reality is she's been a part of our legal team from the very beginning because she's continued to literally incriminate LIEnette and Crook and feed us information all about them. And the rats keep jumping the ship. So let's take a peek here because we've got quite a few pages. Aereo, and this is the case law, supports Hale's preservation argument. Respondents reference. This means Silverscam's mentioning the Aereo case, which is 1D22-1235, and actually supports Hale's points on the issue of preservation. Let's take a gander how legally. So what it says here, as well as the issue of bias. In Aereo, as in Hale's, there was Silverman, Judge DeThomasis, Mark Feather triangle on the trial court level, and with the undersigned firm Shockett Law Group petitioning this court for the writ of prohibition on behalf of Feather's client. So, Shockett, Randy, and Doreen, who I've hired as well, it's all the same. It's just a different case. I hope you get that. And I hope that you understand throughout this process, the biases of DeThomasis is just glaring at the appellate courts. Now, the unbiased toward Silverscam is glaring. The bias against Feather and Shockett is just glaring to the appellate courts. In both cases, number one, Feather's client was the proponent of the disqualifying Judge DeThomasis for bias. And number two, Judge DeThomasis denied disqualification in an excessive, overwritten order, which took issue with Feather's motion and at least one dig at Feather himself. Although no order to show cause issued in Aereo, a response from Attorney Silverman's side was requested by the court. Now keep this in mind, okay? Keep this in mind. All the same players, all the same outcome, and it's becoming so clear to the appellate courts what's really happening in this courtroom. Complete and total biases. All right. However, unlike in Hale's court, his case, Feather's client did not present Judge DeThomas with a successive disqualification motion after receiving an order that itself created an independent bias for disqualification. This is what Doreen is saying. Every time DeThomas said no to the disqualification order, and he went on this huge justification of his inappropriate behavior, if not illegal, he actually incriminated himself further and gave more reason why he should be removed from the case and the bench. Instead, petitioner went straight for the writ, arguing the excessive content and adversarial tone of Judge DeThomas's order as the basis. And although the respondent attempts to suggest that this court's denial of the writ was tied to the timing of the writ petition, this is Doreen saying that Silver Scam is trying to say that the timing is the entire issue, right? So respondent has absolutely no way of knowing that because the panel merely issued an unelaborated denial of the writ petition and motion for rehearing. Because an unelaborated denial provides no reason for why an extraordinary writ of petition is denied, we cannot rule out the lack of preservation may have been such the reason. Okay, so here's what Doreen is saying. Remember, the law of preservation means that we must give Judge DeThomas the appropriate time to remove himself when he does wrongdoing. We have to bring it to his attention, and he has to remove himself. And so we have, not once, not twice, 3 times, and then we go for the writ of prohibition. So what Doreen Ingalls is saying here is, because in the Aereo case, where they didn't actually file for him or file a motion for him to disqualify himself, they went straight for the writ of prohibition. The appellate courts denied it. If they would have went through the proper processes of motion to disqualify, motion to disqualify, motion to disqualify, writ of prohibition, then it would have been potentially actually granted. And so she's saying this actually supports what the Hales. Never had such a great free lawyer in my life. Okay, so we go on to then say the need for Hales to have filed a successive disqualification motion under these circumstances therefore became all the more compelling in light of Aereo, because that process wasn't followed in Aereo case, but it has been in the Hales case. The proper process has been followed, therefore disqualification is imminent, meaning could happen at any moment in time. Nonetheless, the district court's disposal of an extraordinary writ of petition by unelaborated denial means nothing to Hale's case or any, there's a lot of pages here, or any other cases for that matter. An unelaborated denial of an extraordinary writ of prohibition has no res judica effect on precedential value. All right, those are some big words.
Big fancy words.
Can you read that? Unelaborated denial of an extraordinary writ petition has no res, what's that word? Judica?
You know I can't read.
You know, these are court words, and this is not our normal jargon.
No.
Effect of precedential value. And then we have cited Tops versus States. And this is why you hire good lawyers, because they know the jargon, they know the terms. Hey, I'm a 10-year-old in a 47-year-old body, and I am not ashamed of it. So I can't even read. The fact that I even attempt to read this upside down with lights flashing in my eyes in itself is a miracle. Okay, regardless of whether the unelaborated denial of the petition for writ of prohibition in Aereo in 2022 inadvertently empowered Judge DeThomas to keep drafting excessive orders denying disqualification motions contrary to the law found in Section 38.10 FS and Rule 2.330H, the problem is certainly ripe now for this court to address in a meaningful manner. In other words, because the appellate courts did not grant the writ of prohibition in the Aereo case, all they did was empower DeThomasis to continue this behavior. Now, this is something we've continued to say about LIEnette and Crook, because Florida and the state of Florida and every other state and everything such as Puerto Rico, they all must, in good faith, actually enforce a civil protection order from any other state. In writing, the state attorney told the sheriff at Levy County to not enforce it, completely and totally incriminating and creating so much liability in the state of Florida. They went against state law, they went against federal law. And what they've done is continue to empower Crook and LIEnette to continue to break the civil protection order. You've also seen this with Sergeant Dean, who went on with this ridiculous report saying, "The report is over." What exactly did he say about you in that report again?
He said something along the lines on any reasonable person would not be filming standing by the driveway. Really, because Levy County Sheriff will do nothing unless it's video recorded. There were multiple eyewitnesses that saw Crook point a pew-pew at another Otter Creek resident. And when the law was called, when Levy County Sheriff arrived, you want to know what they did?
Nothing.
They did nothing. Do you want to know why they did nothing? Because it wasn't filmed.
Wasn't recorded. And then what happens is we have morons, complete and total fools who shouldn't even be in this office, such as Sergeant Dean, coming out and going, "Oh, because George filmed, she was provoking." I'm sorry. So George is on her property, filming for her protection, says nothing at all, does nothing at all, somehow provoked LIEnette
I'm the
to
one
put
soliciting.
her window down.
Right.
Somehow provoked LIEnette to put her window down. Somehow provoked LIEnette to say, "Oh, so afraid," and break a civil protection order. Sergeant Dean empowered LIEnette. Sergeant Dean actually is giving all the power to LIEnette and Crook to continue to break the law. And this is exactly what's being said in this paperwork, that the appellate court empowered DeThomasis to keep doing this illegal activity. So I'm sure you've seen it. Now, Ohio has found Crook and LIEnette guilty, and all of what's happening and has happened and that Florida continues to turn their back on, Ohio is still going to find them guilty. They have another court case in Ohio on July 19th. And so you understand the principle that's being said here. Hey, if you continue to allow this man to do this, he will continue to do it and break the law. So we then go on to say, if nothing else, respondents' deja vu reference to Aereo, which that is in the response from Silver Scam to the appellate courts. He says, this is nothing but deja vu all over again, because he's responding to what he went through before. So then Doreen goes on to say on my behalf, if nothing else, respondents' deja vu reference to Aereo would certainly suggest that Judge DeThomas's personal bias against attorney Mark Feather began years before he appeared in court with Jeremy Hales on November 29, 2023. Not only has this judge antipathy, which is the there's empathy in empathy, right? And hostility towards Feather continued, as evidenced by no less than 16 derogatory references to Mark Feather on the hearing on January 23rd, 2024. But it also engulfed attorney Shockett, co-counsel to Feather. Yeah, you've heard that. Your co-counsel, Mark Feather, said in 15 minutes, and other members of the Shockett law about the timing of Hale's motion for the stay and its impeding writ of petition. And this is quoting, particularly right here, this is quoting DeThomas's. He says, now the motion to stay amounts to saying, we plan in the future when we get to it, because I'm not belittling the intervening other requirements that counsel has both with courts and outside of court, but I'm saying I'm going to get to it, but I need more time to get to it because I've got other more important things to do, my client's cause in this case. So let's continue it again. It says that there's already been a ruling creating further grounds for disqualification. So another motion for disqualification is likely to come, or a writ. I don't know which, but you've had time to do each. The rules require it to be timely. So I'm being asked to delay a case again because we intend in the future to take further action by filing a writ which we didn't timely do yet? That's the Thomases speaking, derogatory towards my legal counsel. Although even respondents' counsel immediately recognized the incredulity of those comments, stating, I don't think there's a reasonable argument that they have filed a writ of prohibition on the third one between the time you entered that order at about 10 a.m. this morning and now. The respondent still resonates with the judge's misplaced criticisms about Hale's timing. In other words, Silverscam actually put DeThomasis in his place and said he didn't do anything wrong. But then DeThomasis went on to continue to criticize. Again, Silverscam helping me, which I assure you, this individual wants out of this. This individual does not want to represent LIEnette, nor does anybody else in her sphere of influence or life. So we go on. Likewise, respondents' contention that Hales continued to participate in extensive proceedings before the trial court judge. Remember, this is Silverscam saying, well, why are we getting the writ of prohibition now? When Jeremy went ahead and continued to participate in extensive proceedings before the trial court judge. The judge did illegal things that I had no other options. Echoes the same misrepresentation points advanced by the judge on February 28, 2024. So we're going to look right here. It echoes the same misrepresented points, okay? And this is Judge Craig DeThomasis, what he said. There was the first motion to disqualify on December 21st, order denying on December 26th, no writ sought. There was a second motion to disqualify on February 11th, order denying on February 14th, no writ sought. Despite the order denying the disqualification and no writ sought, and despite the fact that the writ of prohibition is the recognized proper avenue for immediate review of whether or not disqualification is an appropriate remedy, additional motions were filed on February 16th, 2 on February 18th, 1 on February 27th, all on behalf of the respondent. Additional requests by counsel for the respondent for a hearing time. The court scheduled the hearing time for today. In other words, Judge Craig DeThomasis literally points out that we did the right process per the rule of preservation. The fact is, there were no court appearances before Judge DeThomasis after January 23rd until February 28th, which was the last one, and when Hale's motion for stay and his time frame to file the writ of petition were addressed. That Judge Craig DeThomasis chose not to rule on Hale's third disqualification motion until the morning of the scheduled court appearance on February 28th, was beyond anyone's control. Oh, well, there is one person, Craig DeThomasis, could have controlled it, and he did, and we had to wait before we could file a writ of prohibition. Nonetheless, Hale's petition for writ of prohibition was filed 2 days later to avoid trial before a biased and a rogue judge who stated in no uncertain terms. This is a quote from DeThomasis. Obviously, I don't think it's going to come to fruition. That was Craig DeThomasis. You want to talk about bias? He's bleeding with bias. Furthermore, merely because a motion to disqualify is under consideration by a trial court judge does not mean parties must cease all filings with a clerk of court, especially if rule-driven deadlines have to be met. Now, what she's saying here is the judge gave them deadlines to meet for filings. They had to continue normal process in court because he refused to actually give a decision on those motions to disqualification. And when he did give a decision, we still had to move forward as if we were still in a normal process until, remember that rule of preservation, we finally said, all right, he's been given 3 opportunities. We're filing for a writ of prohibition. All right. Nor does it mean parties must otherwise discontinue efforts to progress the litigation outside of the presence of the biased judge, particularly in a situation like this case involving a domestic injunction, which is statutorily fast-tracked for resolution. All right, right here. Right here. Prohibition is not among the extraordinary remedies that are subject to a jurisdictional time limit. No set in stone temporal, what's that? I can't read it. Yardstick exists for determining reasonableness. Instead, each case must, I'm doing this all upside down. Can you take it from there?
Then don't read it upside down.
Can you take it from there?
Must be judged on the facts and circumstances presented by, not by some ad hoc or impromptu litmus test.
Based on Colbert versus State. Okay. So, we go on here, Judge Makart concurring, although Judge DeThomas's uncanny ability to draw us back to the never-ending loop that always began and ended with Mark Feather, could certainly test the reasonableness of those limits because of the continuing tour of his commentary. In other words, he hates Mark Feather. He's biased against Mark Feather, then it bleeds down to whoever Mark Feather represents, and then he can't shut up. He constantly wastes time and wastes people's money in court. He won't shut the Hales up. Then here we go. The relevant dates in Haight's amended petition are very clear-cut and undeniably within the bounds of all reasonableness for proper review by this court. All right. Point number 4. Respondent fails to comprehend the difference between adverse rulings and deprivation of due process. So this is, again, part of our argument. Now, they don't understand. Silverscam incorrectly talks about adverse rulings and deprivation of due process. And what he's calling adverse rulings, we're calling deprivation of due process. I'm going to move this pillow right here. Okay, get myself bumped up here a little bit. Now, understanding due process has been stolen from me. My amendment to freedom of speech was stolen from me. My amendment to actually protect myself and bear arms was stolen from me. My access to my property was illegally stolen from me. My due process was stolen from me. And so many more of my rights have been infringed on by this judge. So we go on to say, respondent's dismissive generalized remark that Hales and his counsel merely complain about the adverse rulings. That's what Silverscam is saying. All Jeremy and his counsel does is come in here and complain because they didn't get it the way they wanted it. I'm curious, what would Silverscam do if this was happening to his client? Oh, that's right. Come in and say, hey, this isn't right. But we don't call it complaining. We call it motions and arguments within the court system. Suggests that the respondent has not read Section 4 of Hale's amended petition. That section deals with Judge Thomas's repeated violation of Hale's procedural due process rights, review of which is not subject to time limitations due to the fundamental nature of such an error. In other words, there's no time limitations because Judge Thomas keeps doing the wrong thing. How hard is it in life just to do the right thing? Now, I get it. We have a sin nature. I get it. We're selfish by nature. But you can fight that and you can change that. And you can go, you know what? I'm going to be other people focused. I'm going to help people. I'm going to do these things. I'm not going to be selfish. I'm going to be other centered, not self-centered. But this judge is very, very self-centered. All right. Adverse rulings contemplated the ability to appeal them. Now, do you understand that process right there? Let's read this again right here. Adverse rulings contemplate the ability to appeal them. So in other words, Silverscam is saying he's just complaining about getting rulings that he's not okay with, such as a motion to disqualify Thomas. He says no. And so that would be the adverse ruling. I'd be going, well, I'm not happy about that. Well, by the very nature of the court process, I appeal it. That's the way the court works. So why in the world would Silverscam throw this in a document? Laziness, doesn't want to represent LIEnette, literally tossing a softball to me and saying, knock it out of the park and bury this woman. You know, it could be in court. It could be a number of different things. So we're going to keep going on here. So calling the respondent to task, what rulings has this Judge DeThomasis actually made in this case, apart from entering excessive orders denying disqualification that is not in conformity with the controlling rule or statute? In other words, DeThomasis hasn't made any rulings in this case. I've never even had an opportunity to speak yet. The only thing this man has done is given these verbacious denials of essays of justifying his illegal behavior.
He badgered you about your flight to Ohio.
Well, we're going to get to that as well. In other words, as you can see here, disqualification that is not in conformity with the controlling rule or statute. In other words, he's breaking the law. On December 4th and 5th, when considering Mark Feather's December 1st motion for continuance, the judge entered two prejudicial this is going to be Latin, which is a lot of what we use in court, sua sponte ex parte orders, containing a surprise command for Hales to produce proof of having attended an Ohio court hearing on the morning of November 30th, 2023. These orders are not appealable. Nor were they appealed, because they're not legally appealable. Additionally, once it was explained to the judge at the start of the December 6th hearing that no such Ohio hearing took place, but Hales had to fly there on the morning of November 30th to attend to the matters related to his stalking injunction against the respondent, LIEnette CROOK, Judge DeThomasis nonetheless decided to conduct an on-the-spot compliance inquisitory of Hales on the collateral matter. Completely and totally illegal. The judge then orally found Hales was in non-compliant with the December 4th and the December 5th ex parte orders, and he did so despite knowing that Hales' compliance was impossible. It was an impossibility before even asking the first question. In other words, he found me guilty knowing that I could never, ever produce what he asked for because nobody ever said there was a court hearing. He mandated I must prove I was at a court hearing when nobody said there was a court hearing. There's no way I can prove something that never existed on that day. In other words, he found me guilty for something I could never prove and that was never even stated.
Another reason why video evidence is so important.
Even if a written order memorializing the ruling was entered, it too would not have been appealable as a final or a non-final order. The prejudicial effects of these sua sponte ex parte orders, along with Judge DeThomasis' Arabic characterizations of attorney Mark Feather related thereto, however, never stopped. In other words, if we wanted adverse rulings, as Silver Scam is saying, we're just mad because we got adverse rulings. If there's a ruling that we can appeal that was wrong, which has been to disqualify DeThomasis, we've brought it to his attention under the rule of preservation. But the other things that he did to me, which were illegal and immoral and just downright wrong, we can't appeal that. And therefore it wasn't appealed. Also, on December 4th, 2023, despite having previously denied respondents' injunction petitions or having merely set them for a hearing, Judge DeThomasis finally entered a temporary cyber-stalking injunction ex parte against Hales based upon respondents' supplemental affidavit containing brand new allegations filed that very day. Now, let's just pause right there. We all know what that supplemental affidavit stated. It stated that Mark Feather tried to pay her off. Now, let's get back to the meat of this because it was Mark Feather who was told by DeThomasis, see if you can work something out. So if there was communication between Mark Feather and LIEnette, there's nothing wrong with that. But then LIEnette files supplemental affidavit stating not that Jeremy Hales did anything. She states that Mark Feather tried to pay her off. Now, let me be extremely clear. I have told every single one of my lawyers from the very beginning, this woman will never, ever, ever receive a penny from me. As a matter of fact, legally, she can't even receive a penny from me. Even if she were to win in court, she still can't receive anything from me. And that's how I've set my life up, okay? And so there is nothing to receive from me because I own absolutely nothing. Not a bad gig, being broke. But
you own that shirt, though.
Hey, not only do I own it, I wear it well. Not as well as you, because you've got one now, too. But You understand where this is all going. All right, so it was not what Jeremy did, which made a temporary injunction come into place. It's what LIEnette said and lied about Mark Feather, which made the temporary injunction come into place. Nothing that I've done. Although Judge DeThomasis immediately deprived Hales of procedural due process by setting the return hearing for 2 days later, he exacerbated the problem by giving Hales and his new attorney Shockett an extremely difficult time about continuing it to another day, notwithstanding that Hales was only just served with the temporary injunction. Look at this. Just served with the temporary injunction containing new allegations that very day in open court on December 6th. This is the emphasis here, in open court. You are not legally allowed to be served in court in front of Judge Craig DeThomasis. He allowed me to be served in his courtroom, yet again allowing illegal activity. Frankly, at this point, I'm not even sure I've seen anything legal happen in that courtroom. I was served on camera in that courtroom illegally. You cannot be served in the courtroom in the state of Florida. It's baiting, and you're not allowed to bait somebody that way. It's insanity what this man is allowed to happen in this courtroom. All right, the temporary injunction must await finality before it can be appealed, either by way of contesting hearing on the injunction itself or contested hearing on the motion to dissolve. And then you can see here that we have case law right here, a lot of case law right here. But I think we already know that. The only way to get rid of this injunction now that DeThomasis has illegally placed on me is for it to be heard out in court or for it to be dissolved in court. And that means through the court processes. Hales cannot get finality because the judge bias has been standing in the way. And you realize the court process hasn't moved forward because this man is biased, beyond biased, doing immoral, illegal things in this courtroom. And therefore, he is denying me of due process, of the finality of my hearing because of his complete and total disdain and hate of Mark Feather and now of me and of Randy Shockett and of Doreen Ingalls. And I want to be very clear, there are a number of attorneys that are coming together and going to the appropriate authorities to have him removed. This isn't just happening to me. You know about it happening to me because I'm sharing it with you. This man's been doing this to a number of different people, destroying people's lives and livelihoods. And they want to talk and they want to share their story. And I'm a citizen journalist. YouTube is the largest media platform of news in the world. I don't want this to happen to anybody else, and others want to share their story, and there will be appropriate time for that. It's not yet. And we keep telling them, just wait, just wait. And there are others that we have shared a part of this story that we've made deals with, that we have said, hey, we will not communicate about them anymore as long as they keep their end of the deal as well. And this isn't quid pro quo. This is just human decency. Those same individuals want nothing to do with the Thomases. The temporary injunction must await finality before it can be appealed, either way by contested hearing in the injunction itself or contested hearing in motion to dissolve. We can't get finality because of his bias. Furthermore, on December 6, 2023 and January 16, 2024, Judge DeThomasis entered 2 more sua sponte ex parte orders to preserve video footage from the parking lot cameras outside of the courthouse, which could only have come from receiving extra record information as shown on the face of those orders. Now, let's pause right there. What happened on those days? On those days, John Crook was breaking and violating the Ohio Civil Protection Orders. He was within 500 feet of myself and George on the road, which he legally cannot be on. And so my lawyer, Randy Shockett, went to go get proof for that as we continued to move forward in court of that, which then LIEnette then goes screaming into the courthouse, his attorney! And then DeThomasis says, I want all that video footage preserved. Yes, please. You think we're not going to use that against LIEnette and Crook? Absolutely we are. Absolutely we are. Since then, George has had to call the local sheriff to remove Crook from the road and put him in 500-foot boundary and
Especially
protection.
since she's even wrote to the court that he's not a witness and wanted to dismiss him as a witness.
Which could only have come from receiving extra record information as shown on the face of those orders. Those orders likewise are not appealable, yet the prejudicial effect or potential thereof lingers. I'm going to need help with that one. Any idea what that is?
Malingers.
I don't know what that one is either.
Never
Remember,
even heard
10-year-old,
that word.
47-year-old body, I just want to have fun and enjoy life. And yet there are people who want to stalk me and make my life a living Hales. All right. Given this record, for the respondent to say the wholesale violations of Hale's due process rights were merely adverse rulings is nothing more than a cop-out. In other words, Doreen is saying, Silver Scam, suck it, is what she's saying in the most polite and the most proper way in the court hearings. To sit there and say that Jeremy Hales is just mad because he got adverse rulings when all of his rights have been taken away from him. And she says is nothing more than a mere cop-out. Bad lawyering is what it is. I mean, frankly, it's good on our side because he sucks so bad. What occurred at the hearing on January 23rd, 2024 is a representative of the continuing tour of Judge Thomas's bias demonstrated throughout Hale's case. Yet, in the microcosm of that hearing, we saw, number 1, excessive participation by the judge. Number 2, advocacy for one side by the judge. Number 3, accusations by the judge that one of Hale's lawyers was untruthful. Number 4, antipathy and hostility demonstrated by the judge towards all of Hale's attorney, including prejudicial, what's that? Upside down, I can't. Gratuitous remarks. And then gratuitous remarks by the judge against Hales himself. Number 6, obvious what is that? I can't read it. Disparate treatment of the parties' counsel. Number 7, selective application of procedural rules as between the parties. Number 8, improper burden shifting to Hale's side of the case. Number 9, prejudgment of issues. Number 10, due process violations. And finally, number 11, elaborate excessive orders denying disqualification motions that violate Rule 2.330, Florida R. Gen. Prac and Judicial Admin, and of course, the audio-visual recordings of that proceeding on 1/23/24, which the appellate courts are receiving. Now, first of all, it's very, very difficult to read upside down. I challenge you to do it sometime. If you think you can do it better than me, please make a YouTube video of it. I need help. And some of these words are not words that I use every day. That's why you hire professionals, and this is extremely professional. There are 11 points here. 11 points of what this judge has done, and this just skims the surface of what he has done wrong. And it captures it all, allowing us to readily observe Judge Thomas's clear and obvious bias through the lens of the litigant, Jeremy Hales. In other words, the video doesn't lie, which is why we video when we need accountability, which is why George videos when LIEnette is coming near her, which is why I have to video what's happening in Otter Creek. How many videos has anybody seen of Hale's headquarters with any neighbors, with any issues, with anything in the village, with anything surrounding? Been here over 2.5 years. None. You've seen absolutely nothing. You've seen joy, you've seen happiness, you've seen rest, you've seen peace. We're surrounded by beautiful people, and we appreciate that, and we're blessed that way. Conclusion, as you can see here, this is the conclusion. Petitioner Jeremy B. Hales respectfully request that this court grant his amended petition for writ of prohibition and issue a writ of prohibition prohibiting Judge Craig Thomas from further participating in Preston versus Hales, Levy County Circuit Court 2023 DR-146, and such other reliefs as this court deems equitable and just.